Thank you so much for watching this video. Today we're going to be talking about the DC Voluntary Sentencing Guidelines and the DC Sentencing Commission that creates the guidelines. So first we're going to start off with who the Sentencing Commission is. The DC Sentencing Commission is an independent agency in the District of Columbia that implements, monitors, and supports the sentencing guidelines. The guidelines are created to promote fair and consistent sentencing policies in the District of Columbia. The agency helps to increase the public's understanding of these sentencing policies and practices, and the Commission works to evaluate the effectiveness of the guideline system. The Commission receives data from the DC Superior Court in order to recommend a data-driven policy changes based on practice and research. Now, the Sentencing Commission has a statutory membership that is made up of 15 voting members and 5 non-voting members when it is at its full membership level. Also has 9 staff members as well. Now, the Commission is a resource no matter who is reaching out, whether that is sentencing judges, practitioners, law clerks, or members of the public. Commission staff are available every business day to provide information about the guidelines and to assist users with applying the guidelines in specific cases. The Commission provides advice on scoring out-of-district offenses, the application of the guidelines themselves, as well as to respond to data requests. But I really do want to emphasize that advice from the Commission is not binding on the court. Rather, the guidelines themselves are entirely voluntary. So the Commission cannot provide legal advice, nor does the Commission opine on factual determination. Ultimately, there are limitations to what the Commission can provide information on, but the Commission will do its best to either provide guidance as to what place the manual can provide information on, or hopefully point you in the right direction. So if you do have any questions, please don't hesitate to reach out and the Commission will do its best to answer your question. So today we're going to be talking about the 2025 Guidelines Manual and highlighting the differences from the Guidelines Manuals in the past, specifically the 2023 Manual. So if you're more familiar with that version, we're going to be talking about those differences. And then we're going to be doing an overall discussion of the guidelines themselves and talking about these new chapter breakdowns. So to get us started, the 2025 Guidelines Manual came out and it was effective on April 1st. It's available on the Sentencing Commission's website. And it was a significant structural update from the guidelines manuals in the past, which really hadn't occurred since the manual came out back in 2004. I do want to emphasize that there really were only minor substantive changes. Really, this was a structural change with an update to visuals, examples, to change the flow of the manual to hopefully make it easier both to find the issues and topics that practitioners and people reading the manual are looking for, and just make the flow make a little bit more sense. So on your screen is the 2023 Manual Table of Contents. This is the table of contents that the manual historically has had for a significant amount of time that really clumped topics together, including Chapter 2. Chapter 2 clumped a significant amount of topics together: lapse and revival, out-of-district scoring, different pieces of information, making it difficult to really find these common topics. However, the new manual instead breaks down these topics in the order that a typical guidelines training takes place and separates them out. So as you can see on your screen, each chapter highlights a different topic, and then within these chapters as well, breaks down these subsections into different titles. So again, it's not that the rules themselves has changed, rather the structural changes are intended to make it easier both to find the same rules and also just make it easier to cite them. So hopefully it is just a visual update that is easier to read and easier just to find what you are looking for. But we know that it is a little bit different from what you're used to seeing if you are familiar with previous versions of our manuals. We also have an update to our table of contents. We have a table of tables now to make it easier to find different pieces of information, table of examples, and a list of abbreviations and acronyms to make it easier to understand the manual itself. All of our examples are now pulled out and placed into separate boxes, which are all labeled and numbered. And we've also increased the use of visuals as well as colors. All of our examples also have the reasons and citations to the section listed next to them. So again, we're really trying to pull out and make finding all this information easier. Some of our examples were buried within the text, somewhere in boxes. We're really trying to create uniformity and consistency with the manual to make it easier to find all of these pieces of information. Now, with this process, because of the shifting of some pieces of information around, it did make some sections of the manual that were previously in the text either redundant, or we found that some users were just not using them as frequently. So we did shift some sections of the manual online. So Appendix CI, formerly Appendix CI, is now Supplement 1. That is the chart in order of DC codes citation. Appendix D, which is the ranking chart, most common offense, is now Supplement 2. Chapter 8, which was frequently asked questions, is now Supplement 3. Chapter 9, hypotheticals, is Supplement 4, and Appendix E, guide to split sentences, is Supplement 6. Again, all these are available still on the Commission's website. They're just no longer located in the manual itself. All right, so that is just a highlight of the changes to the manual. I really recommend, if you haven't downloaded it yet, to download the 2025 manual. But if you've had any issues finding anything, please don't hesitate to reach out to the Commission and ask any questions. So let's just talk generally about the guidelines themselves. So the guidelines were created to promote certainty, consistency, and adequacy of punishment. When we have two defendants who are being sentenced for similar crimes with similar criminal backgrounds, we want them to receive similar punishment. Now, the guidelines take two primary factors into consideration: the criminal history score of the defendant, their criminal convictions, and the seriousness of the offense or offenses they're being sentenced for. Those are the only two factors being taken into consideration for the guidelines recommendation. Ultimately, the sentencing judge is going to determine all of these pieces of information. They're going to interpret the guidelines rules. And I really want to emphasize the guidelines themselves are voluntary. Judges are only obligated to give legal sentences. So once the sentencing judge determines the defendant's criminal history score, the judge is going to ultimately determine whether they want to follow that guidelines recommendation or do they want to depart. They consider ultimately what is the appropriate sentence in that case. The guidelines themselves are governed by a rule of lenity, meaning that ultimately, at least initially, the defendant is going to receive a benefit if there is ever a debate between two things. This is seen most commonly with out-of-district scoring. At least initially, the defendant is always going to receive the lower scoring, the least severe offense. However, that doesn't mean that they can't receive the more severe scoring. That just means at least initially they're going to receive the lesser scoring. In 2024, we saw 95.5% of cases were compliant in the box, meaning the defendant received the recommended sentence range as well as recommended sentence type. So that is significantly high, and we've seen consistently high compliance in the District of Columbia. However, we never expect that number to be 100%. The guidelines can never account for every single case, every single scenario. So we really do look at the cases that are non-compliant. Why are they non-compliant? Is it because of that specific factual scenario? Are we seeing trends? Is it different offenses? What are the reasons? So we really do take into deep consideration why and what reasons are cases non-compliant, and drilling into those to see what trends can be found from those, if there are any. All right, so how are we going to go about determining a defendant's guidelines recommendation? We're going to be talking about each of these. So the first step is locating the offense severity group. The next step, which typically is the most complicated, depending on a defendant's criminal background, is determining the defendant's criminal history score column. This is also the section that the commission receives the majority of questions on, so we're going to be spending the majority of our time talking about this section. Once those two steps are completed, we then find the defendant's guidelines recommended sentencing range and sentence type. And then ultimately, we also look if there's an enhancement or a special rule applied. That is not in every case, but we will be highlighting where in the manual to find those pieces of information if it does apply in that case. All right, so our first step, determining the offense severity group for the offense or offenses the defendant is being sentenced for that day. So again, this is just for the instant offense. Now, the guidelines only apply to felony offenses. So if a defendant is also being sentenced for a misdemeanor offense, there's not a guidelines recommendation for that. The judge is just going to sentence them. There's not going to be a guidelines recommendation. Now, in Appendix C of the guidelines manual, the commission has ranked every felony offense that's been sentenced in the past 20 years. Appendix C has a wealth of information, the guidelines ranking, the penalty, the statute code. There's a lot of information, but in Appendix C, it's going to give the offense severity group for that offense on there. So it's a great place to go if you are not sure what the offense severity group, or it's just an offense you're less familiar with. So once we have the offense severity group, we're able to go to our grids to see what column we're in. So the guidelines have two grids. We have our drug grid, which ranks all felony drug offenses, and our main grid, which ranks all other felony offenses. The grids work in the same manner. Both grids, the most serious offenses are ranked in group 1. So on the main grid, that's offense severity group 1, and on the drug grid, that's offense severity group 1. So distribution while armed with any drug, possession with intent to distribute while armed of any drug, for drug grid, and first-degree murder while armed, first-degree murder on the main grid. And then they move down in severity to the least severe offenses. So that's D4 on the drug grid and N9 on the main grid. Moving across gets us for the criminal history score columns. Both grids have the same ranges for criminal history score columns, but don't have the same ranges in terms of the range numbers on the actual grid boxes themselves. As you can see on the main grid, there are more boxes. But otherwise, they are moving across, increasing in number as you move in severity of offense severity group as well as criminal history score. All right. So once we know what the offense severity group is, the next step is calculating the criminal history score. So what offenses are we scoring for that? We're only looking at convictions or adjudications, final judgments of guilt. So we're not looking at deferred sentencing agreements, deferred plea agreements, probations before judgment, post and forfeit, or stet dockets. These are offenses that have already been sentenced and are not part of the instant event. Okay, now the offense severity group is going to determine the scoring. So if you recall from our grids, we saw on the side as well that it will say 1 point, 2 point, 3 points as well. So what ranking that offense has will then determine our point value as to how we're then adding up those points. So we'll talk more about that in a minute. But I do want to emphasize, it cannot be conduct from the instant event, and it has to be entered before the day of sentencing in the instant case. Why is that important? We don't want to be scoring offenses that are part of the instant offense. We don't want to be double counting offenses. So if someone already was convicted in Maryland for the same conduct that they're now being convicted of in the District of Columbia, we don't want to double count that conduct, right? We're not going to now count those criminal history points against them. For prior criminal history, if a defendant pled guilty to multiple counts and it's all from the same events, we then want to only score the most serious offense. So even though there are multiple convictions, we're only scoring the most serious offense, if it is from the same event. Whether it's from the same event can also impact concurrent and consecutive sentencing rules. This is always a factual determination whether something is from the same event or multiple events. So the commission cannot provide a determination. The commission is always happy to help provide examples or point out in the manual where this information can be found, but this determination is initially made on the PSR and then ultimately made by the sentencing judge. The commission will never make a determination whether something is from the same event or not. So what factors are coming into play when determining when something is from the same event? So something is from a single event if they were committed at the same time or place or have the same nucleus of facts. Multiple events were committed at different times or places or have a different nucleus of facts. Criminal conduct can cross jurisdictional lines, what we were just talking about, right? That someone could be convicted for the same event in Maryland and also be convicted in DC. This does not change our analysis whether we're looking at single or multiple events. So keep that in mind. We're really looking at these factors rather than how we cross jurisdictional lines. All right, so as we were talking about, how are we then calculating? So the offense severity group really has a significant impact then on the point value for prior convictions, as you can see for Table 2 from the 2025 manual on your screen. M1 through M5 is scored at 3 points, M6 through M7 is 2, M8 through M9 is 1 point, and so on. However, juvenile adjudications have a different scoring, and then we also have revived offenses. We're going to be talking about lapse and revival momentarily, so we'll touch on that in a moment. But the offense severity group has a significant impact then on what the defendant's criminal history score is going to add up to. Prior misdemeanor convictions work slightly differently. They're scored at a 1/4 point each, and they have a 1 point maximum, meaning there is a maximum of 4 misdemeanors that can count for a defendant for their criminal history. For a misdemeanor to be scoreable, it must have a 90-day or more statutory maximum sentence. That's not referring to the sentence that a defendant receives. That's referring to the statutory penalty for that offense. For example, a defendant could receive a 45-day sentence, but the statutory penalty is 180 days. What matters for it to be scoreable is the statutory penalty for that offense. If the penalty for the offense is 45 days, that is not a scoreable misdemeanor. So let's see what this looks like. So on December 5th of 2024, a defendant was charged with theft 2 second offense. The defendant's PSR revealed the following adult convictions. They have an assault on a police officer, misdemeanor. That is a scoreable misdemeanor. They have a theft 2 and another theft 2 conviction, both scoreable misdemeanors. Public intoxication as a penalty less than 90 days, that is not a scoreable misdemeanor. And shoplifting is a scoreable misdemeanor. We now have 4 misdemeanors. So now we've hit the misdemeanor maximum. Leaving after colliding is not a scoreable misdemeanor. Now we have possession of cocaine, unlawful entry, and simple assault. While each of those are potentially scoreable, because we've already hit our 1 point maximum, these remaining misdemeanors are not scored. The defendant's criminal history score is 1 point. I will note, it does not matter which order we count in, right? Theoretically, we could have gone in the opposite order. What matters is we're hitting that 1 point maximum. So typically we see on PSRs that the writer typically goes with the more recent convictions, but ultimately we're maxing out at that 1 point. Now the sentencing judge can see these additional misdemeanors and use that to go in the higher in the range and see additional convictions, but it's not going to move the criminal history score. Juvenile adjudications work a little bit differently. Juvenile adjudications are capped at 1.5 points. Juvenile misdemeanors are not scored. Now there is an exception. More than one prior adjudication for an offense in offense severity groups M1 through M5 are each scored. They must be from separate events, keep in mind, but all others are not counted. So if a defendant has multiple adjudications from multiple events in groups M1 through M5, each of those are scored. But if they have then additional adjudications from separate events in groups M6 through M7 at D2, those are not going to be scored. So let's see what that looks like. On April 15th of 2024, a defendant was arrested and charged with aggravated assault while armed. After a jury trial, the defendant was convicted of unarmed aggravated assault. At sentencing, the defendant's PSR contained the following juvenile adjudications. They have a conviction for a juvenile adjudication carjacking, M5. That's 1.5. We've now already hit our juvenile adjudication maximum. Therefore, unless we have additional adjudications in offense severity groups M1 through M5, this defendant has already hit their juvenile adjudication maximum. So this attempted P with cocaine, while potentially scoreable at a half point, is not scored. Same with the theft 1. However, they also have an armed robbery, which does fall within our exception. It's an M5 offense that is scored. And so this gives them a criminal history score of 3 points. So as you can see, based on all of these point additions, that's how we're coming up then with what criminal history column the defendant falls in based on adding all of these up, based on the factors, including what offense severity group these criminal convictions are falling in. Now, another factor to keep in mind is the age of the offense, whether it has lapse. So what does lapse and revival mean for the guidelines? So the general rule for adult convictions, we're going to talk about misdemeanors and juvenile adjudications in a minute, is that a prior adult conviction counts for scoring purposes if any portion of its sentence falls within the 10-year window before the commission of the instant offense. Now, the 10-year window is the date of the instant offense and the 10 years back. Okay? If any adult conviction falls within that window, it is scoreable. If an offense falls outside of that window, it is considered lapsed. However, if any prior felony conviction or any part of its sentence falls within the 10-year window, it revives all lapsed felony convictions, okay? So if you have an adult felony conviction that is within your 10-year window, okay, separate from the instant offense, it will revive all lapsed adult felony convictions, no matter how old it is. So let's see this through an example. So we have a defendant who has their instant offense, which is March 9th, 2023. That means that their 10-year window dates back to March 9th of 2013. They have 3 different lapsed felony convictions from separate events: an assault with a dangerous weapon, a second-degree burglary, and assault with intent to kill while armed. However, they do have an offense in their 10-year window, an assault with a significant bodily injury. That's a felony offense. That is scored at 1 point. Because they have something in their 10-year window of adult felony conviction, it revives all lapsed felony offenses. So it revives the assault with a dangerous weapon at 1 point, revives the second-degree burglary also at 1 point, and it revives the assault with intent to kill while armed at 3 points because it's offense severity group. So this defendant's criminal history score is 6 points, again, because they have an offense in their 10-year window, which revives all lapsed adult felony convictions. However, if we remove the assault with significant bodily injury from the 10-year window, and we have no adult felony convictions in the 10-year window, only have lapsed offenses, now this defendant's criminal history score, while they still have the assault with a dangerous weapon, the second-degree burglary, the assault with intent to kill while armed, is now 0 points. While the judge can see that they have these prior lapsed felony convictions, it's not going to move their criminal history score. It's not going to move the box across the grid, because they do not have anything to revive these offenses. So you can see what a big impact it is to have an offense in the 10-year window to revive if someone has a criminal history score similar to this. Misdemeanors work differently. Misdemeanors are scoreable within the 10-year window. Again, remember that is the 10 years from the date of the instant offense moving backwards. However, once they fall outside the 10-year window, they themselves lapse and never revive. Misdemeanors also do not revive felony conviction. So if all you have within the 10-year window is a misdemeanor, it will not revive a lapsed felony conviction. It has to be an adult felony conviction to revive an adult felony conviction. Juvenile adjudications operate off a 5-year window, and once lapsed, also never revive, similar to misdemeanors. The only offenses that can revive are adult felony convictions. All right, so let's see this come into play. On May 30th of 2024, the defendant allegedly committed and was arrested for first-degree burglary. The defendant pled guilty to second-degree burglary, which is an M7 offense. The defendant's PSR showed the following convictions in a juvenile adjudication. So we have a simple assault, which is a scorable misdemeanor. We have an attempted robbery, which is an M8 offense. The thing to keep in mind with this as well, right, is we now have a separate adult felony conviction in our 10-year window. So if we have any lapsed adult felony convictions, this would revive them. So something to keep in mind when you're working through someone's criminal history score is, do we have an offense that will revive any lapsed offenses? Attempted CPWL is a scorable misdemeanor. Possession cocaine, scorable misdemeanor. Simple assault, scorable misdemeanor. However, PPW, while a scorable misdemeanor, we've already hit our 1-point maximum. So while it was potentially scorable, it will not be scored because we've now hit our 1-point maximum for misdemeanors. Now, attempted possession liquid PCP is put right outside of our 10-year window. So it has lapsed, but it is a felony, so it revives at 0.25. Assault with a dangerous weapon is also a lapsed felony, and it revives at 1 point. Theft 2 is a misdemeanor, which has lapsed, so it is not scored. Burglary 1 is a lapsed felony, revives at its full 3-point value, and a juvenile UUV is a lapsed juvenile adjudication, so it is not scored. This defendant's criminal history score is then 6.25 points. All right. The final piece of information to keep in mind when doing criminal history scores is out-of-district scoring, right? We have defendants who their criminal history is not all from the District of Columbia, right? They have offenses that were committed in other jurisdictions. These are the bulk of questions that the commission receives. Please don't hesitate to reach out if you have any questions, want to receive guidance on how offenses have been historically scored, anything like that. This will just be a high-level overview of out-of-district scoring, but please do not hesitate to reach out. So the general rule for out-of-district scoring is we want to score it like the closest comparable DC offense, right? We want to score it how the district criminalizes that conduct. How is this offense scored in the district? How is it criminalized? The thing to keep in mind, though, is when it is initially being scored on the PSR or when you are reaching out to the commission is it is not initially being evaluated as a factual analysis. It is being evaluated truly on the elements of what needed either to be proven guilty or what the defendant was found guilty of at court, right? We're not looking at a factual analysis, okay? So something else to keep in mind is that because there are such a variety in the different codes across the country versus the district's code, the parties are able to agree to a score for only for out-of-district offenses before that PSR is created, and then CSOSA and the sentencing judge can then honor that agreement. So if the parties are able to come to an agreement, say a certain offense should be scored as 1 point, then everyone should honor that. Ultimately, for criminal history scoring for out-of-district offenses, the sentencing judge is going to make that final determination for how an out-of-district offense is going to be scored. After the initial determination, parties can challenge the scoring in 2 ways. The closely matched determination can be challenged, arguing another offense more closely matched, whether more or less severe, or the facts can be then introduced based on a preponderance standard. And we'll talk about challenging more in a moment. But first, let's talk about how this initial overview an initial evaluation takes place. So how is the scoring? So the first step is really looking at the criminal records check. This can have a plethora of information. It can be very bare bones. It really varies. But we're looking at what the offense name is. Does it say drug, P-wood cocaine? Does it say a theft amount? Sometimes gives a statutory citation, even a subsection. So it can potentially really help drill down as to what offense occurred. Does it say it was an attempt? Does it say a weapon was involved? Different pieces of information. Once we take a look at that, then the next step is then going to the criminal statute or common law. We look at the statute title. If we know it's a theft, we're not going to then be comparing it to the district's sex offenses, for example. Again, helping to drill down, and then also then analyzing the offense elements. What conduct is being criminalized and how does it compare to the district's offenses, and what most closely matches? How is this conduct criminalized in the District of Columbia? So let's see what that looks like. So we're using Virginia destruction of property with intent, and we're comparing it to DC malicious destruction of property. As you can see on your screen, while not a word for word perfect example, the elements truly do align, including the amounts that we can see that just based on the elements, rather than looking at the conduct of conviction, it is closely comparable to malicious destruction of property in DC, which would mean it would be scored at 1 point. Another example of this is looking at Virginia destruction of property with intent greater than 1,000. Just by knowing that it's greater than 1,000, we can drill down on what subsection we are looking at for the Virginia statute to make it easier to then compare in DC as to what offense and elements, including an amount, to make a comparison for the offense in the District of Columbia. So if you are able to use that and gain that information, then that information can be utilized. In some cases, there is not a comparable DC statute. That's not to say that conduct is not criminalized or is legal in the district, but that type of conduct just has not been put on the books that way in the District of Columbia, or maybe it's partially not comparable, right? It's just not criminalized in that way in the district. So the commission also has rules in the manual regarding non-comparable DC offenses. So if it's classified as a felony, it's going to be 1 point. If it's a misdemeanor with a maximum punishment by 90 days or more, it's a 1/4 point. We're not scoring if it's less than 90 days, etc. So that's important to keep in mind as well. If you have any questions about that, again, please don't hesitate to reach out to the commission. All right. So how do we go about challenging the scoring? So ways to challenge the scoring, again, is the closely matched determination. Whether it's more or less severe, the parties can disagree with what that initial determination is. Or this is when the facts come into play. But ultimately, the burden is going to be on the party challenging this initial determination. And then it's a preponderance standard for the judge to evaluate. The court will apply this new score only if it determines that the conduct of conviction, right, what the defendant was found guilty of or pled guilty to, as opposed to the alleged conduct, more closely matches the more or less severe DC offense. So some reasons to challenge are just that there's an error on the PSR. Maybe it matches multiple DC offenses and the facts match a higher point offense. Or there's additional information from a drug schedule or theft amount. Methods of challenging include a restitution order. Maybe there's a factual proffer from a plea agreement that gives additional information, or a statute was considered in the initial determination, and then there was updated information and another statute should have been considered, or case law is helpful, and it helped point in the direction of another offense. So these are just some examples that the judge can take into consideration if they wish to when looking at challenging for out-of-district offenses. So after all of that, we can now go back to our grids to determine what the recommended sentence is. So how do we go about finding the right box? So our example on the screen is a defendant has a robbery conviction, which is an M6 offense, so we know what column we're in. They have a criminal history score of 2, so we know what criminal history score we're looking at. Go down. So now we know we are in M6C, which is a 30 to 72 month range. If a defendant were to receive a sentence outside of that range, we would consider that a durational departure. Now, the grids not only provide sentencing ranges, but the colors also represent sentence types. Now, prison and long split sentences are available in every box, but they are the only sentence types available in the white boxes. Short splits are available in the light blue and dark blue boxes, and probation is only available in the light blue boxes. So what do each of those sentence types mean, and how do we give a compliant version of those? So let's start with prison sentences. So again, prison sentences are available in all boxes. So to impose a compliant prison sentence, the defendant must receive a executed sentence that's in the box. So we're looking at box M5C. That's the 60 to 108 month box. A sentence of 80 months executed would fall within that box. 54 months would be below the box. So depending on the offense, that might be legal, but for that guidelines box, it is non-compliant, it is below the box. Long split sentences are also available in every grid box. However, they work a little bit differently than prison sentences. So let's use box M5C again, 60 to 108 months. To impose a compliant long split sentence, the total sentence must fall within the box, a portion is suspended, and then the executed portion must also fall within that guidelines range. For example, a sentence of 80 months suspending all but 60 falls within the ranges, right? 80 months suspending all but 60. 80 and 60 both fall within that box. A sentence of 80 months suspending all but 48 would not be a compliant split because the 48 does not fall within our 60 to 108 month box. Again, it could be legal depending on the offense, but it would not be considered a guidelines compliant sentence. Short split sentences work a little bit differently. So we're going to use box M7B, which is 18 to 42 months. To impose a compliant short split sentence, the total sentence has to fall within the box. Portion is suspended for all but 6 months or less, but not all. So a sentence of 20 months suspending all but 2 months would be a compliant short split sentence in this box. However, a sentence of 20 months suspending all but 7 would be a non-compliant split because it's greater than 6 months, but it will also not be a compliant long split sentence because it doesn't fall within the box either, right? This defendant could have received a sentence of 20 months suspending all but 18. That would have been a compliant long split. That's possible in this box. Defendant could receive a prison or a long split, but this is a non-compliant split in this box, 20 months suspending all but 7. So again, it could be legal, but it would not be guidelines compliant. Our final sentence type is a probation sentence. These are only available in the shaded boxes. So to impose a compliant probation sentence, we're going to look at box M8A, which is 6 to 24 months. We're going to impose a compliant in the box total sentence, and we're going to suspend execution of the entire sentence. So a sentence of 8 months all suspended, that is a compliant probation sentence. A sentence of 5 months all suspended, again, could be legal, but it would be a below the box non-compliant sentence. All right, some additional guidance that the manual provides. In Chapter 7, discusses consecutive sentences, concurrent sentences, as well as judicial discretion regarding these issues. Chapter 8 discusses departure principles, aggravating factors, mitigating factors, Rule 11 C1C pleas. Chapter 9 touches on indeterminate sentences, revocation sentences, and not following the guidelines. And then our appendixes. They are mostly the same as previously before. As I mentioned at the beginning, we did shift some things around where there are a few available online, but our appendixes mostly look the same. Appendix C is our offense listings. Appendix D is probation and supervised release. Appendix E is fine amounts. Appendix F is statutory enhancement examples, and Appendix G highlights the guidelines updates to the 2025 manual. If you want to stay up to date with the commission, whether that's ranking of new offenses, new manuals coming out, or just other information about the commission, including interesting pieces of data we're releasing, I highly recommend you stay up to date and connect with us on our social media channels or subscribe to our newsletter. That's the best way to stay connected to us and make sure that you're receiving all the information, as well as make sure you're staying up to date with the latest manual. Well, we really appreciate your time. We're always available if you have any questions, want to request an individual training or training for your group, or just a specific question regarding the guidelines. So thank you so much for your time, and I hope you found this training helpful. So have a wonderful rest of your day.